And fortunately, no injuries with that bomb threat, and the court was able to resume as normal before ending testimony for the day a little earlier than usual, around 4:30. Live 5's legal analyst attorney Mark Peper joins us live from his Charleston offices. Mark, in your time working in law, have you ever seen anything like that bomb threat before? You know, a high-profile murder trial being interrupted by a very real threat. And what do you think it could mean going forward?
Yeah, good evening, Cameron. Surely you viewers out there and y'all on the station and everybody that watched, surely y'all didn't think this week would just go as planned, right? Of course not. This is the double murder Alec Murdaugh homicide trial. In almost 20 years of practicing law, certainly never seen anything like this. Yeah, there's maybe a call here or there, but not in the middle of a trial, right when the jury's getting kind of settled in, right? If you remember, Monday was still full of in and out, in and out. Yesterday, good bit of testimony. Today, 3-4 hours of testimony, and then all of a sudden, we have to evacuate the building. And that's really all they were told. That could play a part in a certain way on the jury's mindset going forward. This case is about safety, murders, weapons, who he said, she said, videos, concern over safety with all the finances and stuff. I wouldn't want to be on the jury, period. But after a bomb threat, the last place I want to be is there. And so something to keep an eye on, whether the jury is really interested and motivated or how quickly they want to go home.
Well, and exactly with that, the mentalities of the jurors going forward, I mean, a very real threat today, potentially on their livelihoods. Do you think there's a chance that this could cause, a mistrial, whether the judge declares it or whether the jury just doesn't come to a conclusion?
Right. Well, conspiracy theories abound all afternoon, right, about maybe who called it in and why it was called in and those types of things. And while they're not allowed to talk about the trial, the evidence, the witnesses, I have no doubt that they're at home telling their spouses and family members what went on today from a standpoint of, we thought we were under attack. We thought there was a bomb. These guys are already in kind of a bunker to begin with, right? Both figuratively and literally. They have a different entrance that they enter each morning. It's the different exit than the public goes in. They're sheltered already in a group in close quarters. They're isolated. It's very lonely. And now you throw in a bomb threat. I think some jurors are going to be really upset tomorrow with how things played out through no fault of their own or anybody else's really that we know of. It was just a hoax. But it does weigh on you mentally and physically knowing that you're already in an isolated environment and now you have a threat of concern to your own safety. Something to keep an eye on for sure as to how this case unfolds in the minds of the jurors who get the only vote. So therefore, they are the most important people.
And Mark, last question. Despite that interruption today, we did get some interesting testimony. We've been hearing about this gunshot residue, a significant amount on a raincoat that Murdaugh had brought to his mother's house the night of the murders. And of course, the defense started today by cross-examining that GSR expert. Do you think this is some of the most direct evidence we've seen so far? The state has a lot of circumstantial evidence, not a lot of direct. And then also, if you could explain the difference between direct and circumstantial.
Yeah, I'd be glad to. We've heard a lot of evidence submitted, testimony submitted, most of which has been circumstantial versus direct. And so what does that mean, right? So let's do a little Q&A, if you will, Cameron, and see where we go with this, and I'll give you an example. So, Mr. Bob, when you got to the station today, were the cars wet around you?
Well, I wouldn't say so, but I guess for the example, if it were raining today, yeah, the cars would be wet.
There you go. And so, were there puddles on the ground?
Yes.
Right. But you didn't see it raining, did you?
It was raining.
Okay, you physically saw it raining. That's direct evidence. Sight, sound, taste, smell, something that you physically witnessed, that is direct evidence. Now, if I asked you those same questions, but at the end, you gave me a different answer to the question of, did you physically see it raining?
No, I did not see it raining, but the cars were wet, there were puddles, but I did not see the rain.
Exactly. That's circumstantial evidence. It's not direct evidence that you're presenting the jury because you didn't see it rain. You don't know for a fact it rained, but you're using your common sense. That is circumstantial evidence. The circumstantial evidence in this case is starting to mount. Here's a perfect example, a real world example, since it didn't rain today. but there was GSR testimony. What we heard from the sled expert is that there were particles on the clothes, none on the shoes, but some on the hands, on the seat belt, okay? That's about as close to being direct evidence as we've received, because that's somebody testifying to what they tested, direct evidence. However, it's not direct evidence as to whether or not he committed the crime or fired a weapon. It's circumstantial, because as we heard on cross, she wasn't able to identify who it was that shot the weapon. She was simply able to say it's possible that he touched a weapon that had recently been shot. It's possible that a blue rain jacket that had a substantial amount of GSR in it carried weapons that had recently been fired. Okay, so it's circumstantial evidence, but about as close to direct evidence as we've got, and it may be as close as we get in the next coming weeks. Something to keep an eye on. But that's really a good example for your viewers. And one more point, real quick, Cameron. The law doesn't differentiate between direct and circumstantial. It doesn't say you have to have direct evidence in order to convict. If you believe beyond a reasonable doubt, based on the circumstances, circumstantial evidence presented to you, that he's guilty, you must convict. That'll be the question presented to them in 2 to 3 weeks' time.
And of course, both the state and the defense clearly have their work cut out for them in presenting this circumstantial evidence. Once again, Mark Peper for us. Thank you so much for explaining everything clearly as per usual. And as always, if you're unable to watch our coverage of the trial in real time, our digital journalists here at Live 5 have got you covered. They give you real-time updates every day of the trial. Just go to live5news.com and click on the live blog.